Hello, everybody. I think we can begin. Good afternoon, good morning, or evening, depending on where you're joining us from. It's really been wonderful to see such interest in this discussion and to have the chance to welcome such a large audience. So I'm very happy to speak to you all today. My name is Rian Derrig. I'm a postdoctoral fellow here at the WMU Sasakawa Global Ocean Institute, and I'm really pleased to welcome you to this webinar on international law on the Nord Stream leaks, an academic roundtable. We've gathered to discuss the leaks that were discovered on the Nord Stream 1 and Nord Stream 2 pipelines on September 26th. And those leaks resulted in significant emission of methane into the Baltic Sea. Now, our focus today is on the international law regimes, the instruments, and perhaps the principles that might be relevant to this event, and on how law might help us address this event, without prejudice, of course, to any determination or attribution, or any investigations that are still ongoing even as we meet today. Now, to help us interrogate what relevance international law might have to this event, we really have a brilliant group of panelists with us today, and I'll introduce each in turn. Our moderator and our guide in this discussion will be Professor Ronan Long, who is our director here at the Sasakawa Global Ocean Institute of the World Maritime University, and holder of the Nippon Foundation Professorial Chair in Ocean Governance and the Law of the Sea. Professor Long is a leading scholar of the Law of the Sea and Ocean Governance. He has a voluminous publication record of monographs, edited volumes, and journals in those fields. He's been a senior visiting scholar in residence at the University of California, Berkeley, and a visiting scholar at the Center for Oceans Law and Policy at the University of Virginia. He teaches on the Law of the Sea program at Harvard Law School, and prior to his academic career, he was also based at the European Commission and undertook missions on behalf of the European institutions to member states and around the world. So we're really lucky to have him with us today, and he has just returned from Sharm el-Sheikh, where he was attending, advising at COP27. Then our first roundtable speaker will be Dr. Danae Azaria, Associate Professor at the Faculty of Laws, University College London. Now, it's fair to say that Dr. Azaria is really the leading expert on this topic. Her excellent 2015 monograph, Treatise on Transit of Energy via Pipelines and Countermeasures, was published by Oxford University Press, and in 2017 was awarded the highly prestigious Paul Guggenheim Prize in Public International Law. Dr. Azaria is also co-rapporteur of the Committee on Submarine Pipelines and Cables of the International Law Association. She's a member of the Advisory Panel of Public International Law of the British Institute of International and Comparative Law, and has held prestigious visiting fellowships and professorships, including a senior Humboldt Fellow of the Alexander von Humboldt Foundation at Humboldt University, Berlin, and as visiting professor at the University of Trento. Our second roundtable speaker will be Professor James Kraska, Charles H. Stockton Professor of International Maritime Law and Chair of the Stockton Center for International Law at the U.S. Naval War College, visiting Professor of Law and John Harvey Gregory Lecturer on World Organization at Harvard Law School. Professor Kraska has also served as visiting professor at the College of Law and University of the Philippines, and has been distinguished visiting professor at Gujarat National Law University. He has been Mary Derrickson McCurdy Visiting Scholar at Duke University Marine Laboratory, and Chief of Naval Research Fellow at Woods Hole Oceanographic Institution. Professor Kraska is a very prominent scholar of international maritime law. He has published very widely in that field. He is editor-in-chief of the journal International Law Studies, which is a very old and fabled US law journal. And he's a permanent member of the Council on Foreign Relations. Our next speaker will be Dr. Jen Zun, associate professor here at our own WMU Sasakawa Global Ocean Institute. Dr. Sun's expertise on the legal regime of the exclusive economic zone is really unparalleled. And of course, these leaks have taken place within exclusive economic zones of Sweden and Denmark. Dr. Sun's very important monograph on the development and practice of states in relation to the exclusive economic zone will soon be published by Cambridge University Press. And Dr. Sun is principal investigator of several high-level research projects here at the Sasakawa Global Ocean Institute. She's published on a wide range of topics within the law of the sea, the international regulation of shipping, gender equality in ocean governance, climate action, and the protection of the marine environment. Our final roundtable speaker will be Professor Alla Podsnakova, professor at the Scandinavian Institute of Maritime Law and the University of Oslo Law Faculty. Professor Podsnakova is a really important voice within a very active frontier body of research at the intersection of the law of the sea and international environmental law. She's co-editor of a very exciting book on this topic titled Environmental Rule of Law for the Oceans, Designing Legal Solutions, and that's forthcoming with Cambridge University Press. Professor Podsnakova holds many editorial and consultancy roles relating to international law, the law of the sea, and also space law. So as I said, it's really a wonderful lineup of speakers that we've been able to gather here today to discuss this event. And we're very much looking forward to their presentations and to the discussion. I'll hand over now to Professor Long to say a few words before opening the roundtable.
And thank you very much, Rain. It's a great honor and privilege to host this event this afternoon, of course, here in Europe, and say a special warm welcome to our audience right across the world. Our alumni in Africa in particular, as well as our alumni in Asia, Australia, New Zealand, Japan, and the wider Pacific. We also say a very good morning to our alumni in the Americas and the Caribbean. International law and the Nord Stream leaks, an academic roundtable. I'd put the emphasis on that latter phrase, an academic roundtable. Generally speaking, in the university, we host our discussions under the Chatham House rule. That is to say that there is nothing in this discussion should be attributed to any person, state, or other entity. We have a very exciting lineup, and what we propose to do is to allow each of our panelists to address the audience for 10 minutes, and then we will open the discussion to a much wider debate of the key issues. Professor Azaria, you've had a wonderful career. You're a noted scholar in the field, and I would like to give you the floor. Please, you have the floor.
Thank you very much. Thank you very much for the invitation and a great lineup of speakers. And I look forward to the discussion with all the colleagues. Now, in September 2022, explosions damaged the Nord Stream 1 and 2 pipelines in the Baltic Sea. These are major transboundary pipelines transporting gas from Russia to Germany that cross the territorial sea of Russia, Denmark, and Germany, and also the exclusive economic zone of Russia, Finland, Sweden, Denmark, and Germany. Now, Nord Stream 1 and 2 are owned as companies. They're owned by and operated by companies that are incorporated in Switzerland. And Nord Stream AG, the company that owns Nord Stream 1, has announced that damages on Nord Stream 1 took place in the exclusive economic zone of Denmark and or Sweden. And non-state actors, nor any state, has claimed responsibility for the explosions. And I will not be addressing today the issue of attribution of conduct to any state. But in a short essay that we published in Eagle Talk, Geir Wolfstein and I relied on this incident to discuss some of the legal questions that incidents such as this one give rise to. And my talk today builds on that particular essay. Now, pipelines are essential for ensuring energy security, and cables are vital for energy security, but also security of communications. And all these concerns have been essential in the priority of states for years. But since the Nord Stream explosions and against the background of an energy crisis in Europe, these concerns have skyrocketed, not only in Northern Europe, but also in South Europe and beyond, such as in Asia. Now, the explosions have been described as acts of sabotage, which may be criminal acts under some domestic laws, but the sabotage of pipelines as such is not specifically prohibited under international law, albeit other rules of international law, including the obligations to preserve and protect the marine environment, may be violated by such conduct. Today, I will focus on jus ad bellum and specifically on the following question. Can the sabotage against an offshore pipeline such as the Nord Stream pipeline give rise to an armed attack against a particular state, which under customary international law and the UN Charter entitles that victim state to exercise its right to self-defense? Now, the main arguments and challenges in answering this question concern, first, the gravity of an armed attack, and second, who is the victim of the alleged armed attack. And these are important because the state that invokes a right to self-defense bears the burden of proving the facts showing the existence of an armed attack against it and by a particular state, according to the ICJ in oil platforms. Now, before delving into these points, I would like to mention that the ILA Committee on Submarine Cables and Pipelines is currently working on aspects of these issues. As a caveat has already been mentioned, I'm a co-rapporteur of this ILA committee, along with my good friend and colleague, Tara Davenport from the National University of Singapore. But my views here do not reflect and they do not preempt the committee's views on this topic. Now, in terms of the force that must take place in order to meet the threshold of an armed attack, it must involve the most grave forms of use of force. Other less grave forms of use of force do not meet this threshold, according to the ICJ, Nicaragua, and oil platforms. In Nicaragua, the court had considered also the distinction between an armed attack and mere frontier incidents and relied on the following criteria to draw this distinction: the scale and effects of the attack and the circumstances and motivations of the attack. And I think that the scale and effects criterion is particularly relevant for assessing whether blowing up major transboundary pipelines may constitute an armed attack. Now, the court's reasoning in oil platforms is also relevant in terms of gravity and about the question of who is the victim of the alleged armed attack. The points from the court's reasoning, which can be relevant by analogy for our purposes, are the following. First, the court expressly has not excluded the possibility that targeting a single military vessel might suffice to bring into play the right to self-defense. Cumulative, less grave forms of use of force could meet the threshold of an armed attack. Now let's consider how these points apply to attacks against pipelines such as Nord Stream. It is arguable that attacks against 3 pipelines of Nord Stream 1 and 2, either taken individually or cumulatively, within less than 2 days, reach the threshold of gravity, that is scale and effects, considering that all 3 major pipelines were also specifically targeted. But I think that the real question here, in relation to the attacks on submarine pipelines, is who is the victim of that attack? And we can envisage 3 categories of states. The first category consists of coastal states. Now, if the attacks against Nord Stream had taken place in the internal waters of a territorial sea of a state, that state would be the victim of an armed attack since it exercises sovereignty in the zones and its territorial integrity would be affected. But the attacks on Nord Stream pipeline have taken place in the continental shelf or the exclusive economic zone of Sweden or Denmark. Now, in these zones, coastal states enjoy and exercise only sovereign rights, exclusively on the grounds provided by international law. There is freedom of laying pipelines and cables subject to treaty and customary rules concerning the coastal states' rights on the continental shelf. The coastal state has exclusive jurisdiction over artificial islands, installations, and platforms in the exclusive economic zone and in the continental shelf, as well as jurisdiction over cables and pipelines that are constructed or used in connection with the exploration of the continental shelf, exploitation of the resources of the continental shelf, or connected to the operations of artificial islands and installations and structures under its jurisdiction. But pipelines that are completely unconnected to such artificial islands, installations, and platforms, or the sovereign rights in the continental shelf, such as the case of Nord Stream, are not subject to the general jurisdiction of the coastal state. So in light of the limited jurisdiction that coastal states have in the continental shelf and the EEZ in relation to this particular category of pipelines, it is difficult to argue that they are the victims of an armed attack. The second category of states that comes to mind is the state of incorporation of the company that owns and operates the pipeline, or other states whose nationals are shareholders of that pipeline company. Now, pipelines do not have flags like vessels do. However, they are owned and operated by companies that are incorporated in some state jurisdiction. It is arguable that the state in whose jurisdiction the company that owns or operates the pipeline is incorporated is the victim of an armed attack, giving rise to its right to self-defense. And in this case, that would be Switzerland. However, until today, I'm not aware of any relevant claim made by Switzerland. However, the company Nord Stream AG has 5 shareholders. These are companies incorporated in Russia, Germany, the Netherlands. Now, the question here would be whether the corporate veil could be pierced to such an extent as to allow a connection between the attack on Nord Stream and the state of nationality of a shareholder. I consider this highly debatable, but in any event, no state whose nationals are shareholders of Nord Stream have made such a claim about being entitled to a right to self-defense. And the final category of states that could allegedly be perceived as being the victims here would be importing or exporting states that rely on the pipeline that is being attacked. Now, importing states may have significant security of supply interests that are affected. The exporting state also faces significant security of demand effects in such scenarios. Now, in the Nord Stream scenario more specifically, the explosion has unprecedented effects on multiple importing states in Europe, unprecedented effects on the functioning of a whole regional gas market, and even the capacity of numerous importing states to comply with some human rights obligations vis-a-vis individuals in their territory is affected, because these states rely on energy access through Nord Stream in order to ensure that populations in their territories enjoy, for instance, their right to health. And this is not completely out of the discussion as an example, because in 2009, with the energy crisis that occurred in Europe, numerous people died in Europe because of that energy crisis. However, I think that this argument faces the following challenge. First, at the time of the explosions, there had been no ongoing gas exports from Russia through these pipelines, and this would lessen significantly the strength of the argument. And second, in any event, the economic rather than the physical effects of the force is not the established criterion for assessing whether instances of use of force reach the level of gravity required for an armed attack. So to conclude, as far as the right to self-defense is concerned, the main challenge in the Nord Stream incident is that of identifying which state is the victim of an alleged armed attack against this pipeline. Thank you very much. I look forward to our discussion.
Professor Azaria, thank you very much for a wonderful tour de force, a great introduction to today's roundtable. And of course, I think this is the essence of your piece in the European Journal of International Law's blog, which is co-authored. And of course, we have many questions in relation to that particular piece, and we will have sufficient time at the end of the roundtable to debate some of the key issues. I'd like to turn to Professor James Kraska at Harvard Law School and, of course, the United States Naval War College. Professor Kraska, you have the floor.
Thank you very much, Professor Long, and thank you to World Maritime University and the Sasakawa Global Ocean Institute for the kind invitation to be able to participate in this event and talk about this incredibly impactful event that happened in September. I guess I would suggest that the line of inquiry with regard to use of force and jus ad bellum and armed attacks is probably not helpful in this instance or this occasion. If we take a step back and look at the law of the sea, as reflected in UNCLOS, says that the oceans are reserved for peaceful purposes, Article 88 and some other articles. And of course, that's imported into the EEZ through Article 58, paragraph 2. And peaceful purposes has always been considered to be activities that are not in violation of the Charter of the United Nations. So the only way you can get into a jus ad bellum situation, in my view, is if you look at this as a threat of the use of force rather than the use of force under Article 2, paragraph 4, which is a pretty thin ice to skate on, but I guess it's an argument that could be made. So peaceful purposes must not be inconsistent with the proscription against the threat or use of force under Article 2, paragraph 4. And I agree that there's absolutely no occasion where this would be considered an armed attack that would trigger the right of self-defense. That would hold true, in my view, not only under the sort of broad gap theory that has been constructed by the ICJ and the Nicaragua decision and the oil platforms decision, but even under the US view that does not observe a gap. That is, that if there's a hostile act or a demonstration of hostile intent, then force might be used in self-defense. And I would suggest that that is probably not the case here for states that are affected, the ones that were mentioned, Germany, the Netherlands, Denmark, Sweden, Finland, by virtue of their maritime zones or by virtue of their market relationship with Russia. And then, of course, Switzerland, by virtue of its role in serving as a corporate headquarters. So where does that leave us? I think in practical terms, the next step would be to look at whether this is an internationally wrongful act that would invoke some type of state responsibility. States are responsible for breaches that can be attributed to them. So that's a large question mark. Assuming that you could attribute this incident or this attack, which it looks like it was an attack with explosives, then could you impose some type of state responsibility on that state actor, assuming it is a state actor? There's been a number of different theories. The most popular is that this was Russia. Also theories that it was the United States or some European country or Ukraine that intended to magnify the effect of the importance of or loss of Russian gas as we head into the winter. In order for internationally wrongful act to vest, you have to have attribution to the state, and I think that's going to be very difficult in this case. And then further, what does that get you? First of all, you have to have a state that has suffered an injury, which has been discussed. That's going to be very difficult, I think, to ascertain. unless perhaps it's Russia making a claim against some other state. If it's making a claim against Ukraine, then you might argue that this is a war-sustaining function that's a lawful military target. That would be the US view. The European view would be that lawful military targets don't extend to this type of civil infrastructure. But of course, Russia has a broader view, as we know, of what are sort of lawful war-sustaining targets. So if it's Ukraine, then it's possibly Ukraine doing this against Russia, then it's possibly a jus in bello issue. And there, I think most scholars would say that this is a bridge too far, that it's disassociated with the battle space. If it's an internationally wrongful act, then these are secondary rules that are consequences of a breach of a primary rule. And it's hard, again, to identify a primary rule that's violated. But for the sake of argument, you might suggest that the consequence of a violation of an internationally wrongful act would be cessation or reparation. And cessation has been overtaken by events. So then you would seek reparation to fulfill the damages that have been caused. Even so, it's difficult to quantify or to identify those damages. So I think it's in the end quite difficult, either under jus ad bellum or under the law of state responsibility, to get much work out of these bodies of law in this instance. Thank you very much.
Thank you very much, Professor Kraska. And of course, you've raised a number of key issues here, and we'd like to return to these issues in the round table. Without further ado, I'd like to introduce my associated colleague, Professor Jensen here at the World Maritime University. Professor Jensen, you have the floor.
Thank you, Professor Long. Good afternoon, good morning to everyone. My name is Jen, and I work at WMU. Let's fill the gaps before I can find my presentation here. So as Brian mentioned at the beginning, that I did my PhD on the EEZ. So from today's discussion, what I want to bring you back is to the basic legal framework that governs the freedom to lay submarine cables in the EEZ, and put it in a context with what is often put together is the submarine cables, and to discuss the difference or the limitations that is placed under the regime of the EEZ and on the continental shelf, and how it is affecting its protection under international law. So this is a picture I took from the project's website. Yeah, this is better. So this was an illustration to show how the pipelines were laid, and the protection and freedom to lay and the submarine pipelines, associate activities to the laying itself is part of the freedom. So this is just an illustration chart. What I wanted to focus on today is to discuss the limitation to such freedom based on the to accommodate the coastal states' rights and jurisdiction, and to discuss the protection of it. What's the implication to the current incident? The first 3 slides is really just to take you back to the existing legal framework. I think this has been touched on by the previous 2 speakers, is that the EEZ, it overlaps with the continental shelf to the extent, at least in this case, so I just limit my discussion to the EEZ, is that the EEZ is a special regime that is not subject to sovereignty of the coastal state or the entire freedom on the high seas. All the rights and duties, freedoms has to be attributed according to the provisions that is stated in the convention itself. For the coastal state, it has to anchor its jurisdiction that link to the exploration or exploitation, conservation management of the natural resources or anything related to the economic benefit of using the zone. And associated to that, they have been accorded with specific jurisdictions. also largely linked to their sovereign rights over the natural resources. So I think what I want to highlight in the jurisdiction section is that the coastal state does have jurisdiction over installation and structures, but in the UNCLOS context, it has been the submarine submarine cables and pipelines has been exempted from this jurisdiction. For the freedom to lay plans, and I think an important distinction, I think, as Dr. Adrai mentioned, is that compared to the freedom of navigation over flight, cables and pipelines do not have a registry state. In a sense, it doesn't have a national state or a flag state, so that affects their protection when it's come to the international level. Under the Article 58, which defines the freedom, it's have a general statement of the freedom to lay submarine cables and pipelines without defining, the specific concept of cables, pipelines, what they are transiting. The other one is key is to set a limit on other international lawful uses related to these freedoms. And in this, it highlighted the operation that is associated with the operation of pipelines. Sorry, I forgot. Yeah. What I wanted to focus the legal regime on is the limitation that is being highlighted in order to associate the protection, in order to accommodate the interests of the coastal state. Here, Article 79 was placed in the regime of continental shelf. First subparagraph is really just to reassure the freedom is applied to this section, and the paragraph 2 to subparagraph 5 is outlining the specific limitation on such freedoms. And I think what relevant to today's discussion was the part 2 to paragraph 4. First one is stating that coastal states have the right to take reasonable measures for the exploration of the continental shelf, the exploitation of natural resources, and this reasonable measures applies to submarine cables and pipelines. The second phase of this paragraph is that taking reasonable measures for the provision, reduction, and control of pollution from pipelines. And this section was added during the third UN conference on the law of the sea. It was based on a proposal submitted by the US. I think the negotiation background was for the consideration of environmental consideration for preventing of pollution coming out of the pipeline itself. So this is to accommodate the coastal state's jurisdiction. The second one, also highlighting the difference between the protection of, the freedom to lay submarine cables and pipelines, is that the delineation of the course of the laying sub pipelines is actually subject to the consent of the coastal state. If we go to the website or have a look at how the Nord Stream is laid, it took them over 5 years of time to obtain relevant to conduct environmental assessment and obtain the consent from the 5 regional coastal states. So this is those two, the one I highlighted in red are the difference between the submarine cables and the pipelines. So pipelines, if we may put it in a general terms, it's actually subject to a more stringent regulation from coastal state compared to submarine cables. The last restriction that the coastal state have, or the jurisdiction that is given to coastal state, is in terms of they can set conditions for special type, 2 special types. One is that entering its territory or territorial sea. The other one is associated to the operation of offshore platforms. And I think if we look at today's case, the first one would probably be coastal states, where the coastal state can find jurisdiction over a trend-passing pipeline. On the protection of submarine pipelines, there are 3 provisions that is placed under the regime of the high seas, but by reference, it applies to the continental shelf as well as the EEZ. So the protection of submarine cables and pipelines, I think this is from a state perspective, what can the legislative power that they can take. In practice, we have seen industries developing different standards and some national states adopt different regulation or requirements for the protection of submarine cables and pipelines. The general practice, including requirement of barrier to a certain depth, establishing a protective room, or no use of dredging or other uses of the maritime zone to establish an exclusive zone alongside either the pipeline or the submarine cables. So these are the private practice to protect them. From state to state level, it's up to each national state to adopt national laws and regulations to punish or regulate 3 different types of harms, injuries to the cables and pipelines. This apply to the same level on the international level to submarine cables and pipelines, but state practice varies to some extent. This, I think there are 3 different levels. The first one is what is most relevant to today's discussion is the intentional or through culpable negligence cause a damage or breaking to a submarine cable or pipelines. And on clause 3 has extended such jurisdiction to conduct that calculated or likely to result in such breaking or injury. In a certain way, it expanded the scope of the criminal act. So this is up to each coastal or each state to adopt, but you have to find a jurisdiction link under general public international law. And for this, it is only being given states that for its own flags, for its ships that is flying its flag, or a person that is subject to its jurisdiction. The other type of protecting measures is to make sure that in practice, that when laying or repairing submarine cables do not cause damage to the existing one, and also to bear the cost for the repairs. The third protective measures is to encourage private mariners for them to avoid dropping an ankle or a fish net, that they can get compensated for such loss. It's an encourage incentive movement to make sure that they don't cause intentional damage to or by incident. So those are I highlighted the part that the coastal state might have a jurisdiction or to intervene in this incident. So how does this apply to the Nord Stream pipelines? And I think Dr. Azrai sort of laid down the discussion of what are the victim states. And I also consider that what are the relevant states in this case. So we all can agree that it happened in the EEZ of Denmark and Sweden, but we probably will run into difficulty. We can identify who's actually the state that enjoyed the freedom to lay submarine pipelines. I think normally we would go after this, not go after, but recognizing that where the company is registered. But as Dr. Azrai mentioned, that the ownership to this case, if it's over 51% by a Russian company, but the Russian has an interest in showing this. The third relevant state would be, if it's caused by a ship or a national that is rented a ship for this instance, the state might come into play when we're discussing liabilities. The fourth one that I thought was probably bringing some of the discussions is that whether there's any rule for a regional state. We have discussed the most relevant one for the importing, exporting state, Germany and Russia. I wanted to highlight whether the damage to the environment or damage to the seabed could bring in other players into play. But then this is all circumstantial and also depending on what's the final result of identify those damages or in linkage to those states. So if I want to put the spotlight on the coastal state, what can Sweden and Denmark do under these circumstances? If going back to the legal regime that I highlighted earlier, I think the most relevant one or the only one is for them to link their jurisdiction to the reasonable measures for exploration of continental shelf, exploitation of natural resources, or prevention for the pollution coming out of the pipeline. If we look at, I came across some of the new things, and I think this will probably warrant some discussion is that I actually haven't seen them, provide a legal basis when they did all these activities. They established the exclusive zone. They required the owner of the pipeline to apply for a permit before they can send their survey ship into the accident scene. Also, they opened criminal investigation over the incident. I think there are question marks over them, but I think if they really look deeper, they can find jurisdiction perhaps based on the reasonable measures, the damage to the seabed, damage to the potential environment. And also, I think the high question mark that I had was whether the if we haven't considered repairing, but the examination of the damages by the owners, should it be subject to a permit by the coastal state? I think there are different practices on this issue. The other question that I had was if they spotted the perpetrator on the spot, whether the coastal state have the jurisdiction to intersect or even arrest the ship. Then if the coastal state has some subject to any damage to this incident, I think the first speaker mentioned it's going to be highly questionable, or they need to find the support to it. After going through the lawful sea legal framework, it prompted me a few things that I think, as the previous two speakers mentioned, it's pretty hard for us to find a legal grounding for the coastal state to act. So I went a little bit on the box to ask some questions. There are two, I think we discussed about whether it's a wrongful act of a state, assuming it is done by a private entity. And I asked whether we can use the concept of a privacy to invoke the universal jurisdiction over such act. I think the concept of piracy has been used to go after, for example, the Arctic Sunrise case or attack on submarine cables. But whether this can be applied to the pipelines, I think this is still under discussion. The last one I want to raise is on the sewer protocol. I think for me, this probably will be the most relevant for the states to find a jurisdiction over such incident, for example, for the coastal state, because the accident happened on their continental shelf. The sewer protocol was for the suppression of unlawful act against the safety of fixed platform on the continental shelf. It finds that the fixed platform is installed, including installations and structures permanently attached to the seabed. It's normally would link to the exploration of natural resources, but here it also includes for other economic purposes. So for me, I think this would be a legal basis for the coastal state to argue that they can establish jurisdiction. But this is a special treaty, so it only applies to the state parties. But under this case, I think Denmark, Sweden, even Russia ratified the 1988 sewer protocol. So it could be something that's worth consideration. I'll stop here. Thank you very much.
Professor Jensen. Professor Jensen, thank you very much. Tour de force. I think you've opened debate and very interesting arguments, both in the context of piracy and reliance on the SUA protocol. And of course, I would ask some of our other panelists perhaps to reflect on those issues before we get to the round table. We have one more speaker this afternoon. In many ways, one keeps the best wine to last. I hope nobody takes offense there. Professor Alla Poznakova is a very close and dear friend to me and indeed to our university. She's co-editor of an extraordinary book, which is forthcoming from Cambridge University Press, Environmental Rule of Law for Oceans, Designing Legal Solutions. And I think it's a very timely publication, and I look forward to your address this afternoon. Professor, you have the floor.
Thank you very much, Ronan, Rian, and colleagues for the possibility to talk here, and to previous speakers for unpacking some of the issues that are also relevant for my presentation. And Dr. Jensunso, who helped me a bit with the, presenting the Law of the Sea framework. And Ronan, this is indeed an unprecedented event. My take or my perspective is to discuss marine environmental protection issues that Nord Stream explosions, and now we know it's most likely sabotage, raises. And as you were mentioning very kindly, our forthcoming book, Environmental Rule of Law for Oceans, I can tell you that the picture which will be on the front page of this book was taken by me from the sail ship Christian Radich. It's a Norwegian ship, and when these explosions took place, I read on the Facebook update that they're safe. They saw on their monitors, they saw these explosions taking place. They didn't know what it was, but they steered away from that area, and which is of course very good. And indeed, it shows that this kind of explosions are very dangerous for safety of navigation, and they have also brought about environmental impacts. Now, let me just share my slides very quickly. I'm not going to give a very long presentation, but I'd like to just do this. Yes. And we don't know yet how bad environmental impact will be. It's a guess, so maybe it will not as bad as, for example, if it were oil pipeline. But there will be certainly there are effects on the on fish stocks, perhaps also on the benthic species. There is also just yesterday I read news that there is a very significant concern that the explosions have stirred, this chemical warfare agents which remain from the World War II, which is of course a known problem and allegedly specifically in that area. So a significant question is, what do we actually know about the environmental effects of this accidents or this actions? And another impact that I will not go into, but which is I think important to bring up, is that the release of methane is very large. It's I don't know, 2,100 tons or something, according to some report, and so the states will have now to decide who is responsible for for these greenhouse gas emissions. But I will focus on marine environmental protection. And in a sense, it is a pity that this event is such extraordinary, including it involves vicious, willful conduct, and environment might be a collateral damage. But explosions and sabotage of energy pipelines it has happened before. So this kind of what if it were not a willful conduct? What was just an accident? We would also have to look into the marine environmental regime, right? It's high time to do that. And another aspect of Nord Stream, which is peculiar to Nord Stream, I think, and which other speakers also highlighted, is that many states are involved. So we have several coastal states. We have also state of incorporation and state of export, state of import. So I think this is, Dana can correct me if I'm wrong, this is quite unprecedented. I would normally think a pipeline that goes from a coastal state to a terminal, offshore terminal, and but here we have this involvement of several coastal states and other states, and that leads me to a number of questions. I will focus just on a few of them, and one of them is moving beyond, of course, that all states have the duty to take reasonable measures to protect the marine environment. This applies to also to the state where operators of this pipeline come from, but also to coastal state. But what is the role of the coastal states such as Denmark or Sweden here? What is the scope of their jurisdiction? What is the scope of their responsibilities? And these are indeed, I think, questions that cannot be replied to just on the basis of the wording of these provisions, but you see that still coastal states play a significant role in preventing and combating such pollution. And we have seen also cooperation between Denmark and Sweden and other states in investigating what is going on. So this is a good thing. But I'd like to, and I have background from ship source pollution, so that explains why I'm trying to bring some examples from how some of the issues were dealt with in international maritime law with respect to ship source pollution. But I'd like to perhaps just highlight first the problem that arises with regard to preparedness, emergency preparedness and response in cases such as this, because it doesn't really matter whether it was willful conduct damaging or just an unfortunate accident. States have to be prepared. They have to be able to respond, and the question is how. So I think that we have not just law of the sea provisions, we have also regional agreement that says that states have to have some sort of preparedness in place. And just looking very quickly, navigating through the permit conditions, in particular just using Denmark as example, but also other coastal states, we see that the states have actually considered different kind of scenarios. And Denmark also considered possible sabotage or act of terrorism, and they seem to have concluded that it's quite unlikely because of, it's deep sea, seabed where the pipelines are located. So they were keeping this in mind. They were reflecting on that, and they were also reflecting on the need to have some kind of emergency mechanism in place. But still, these questions of how exactly to tackle these leaks that are occurring is I think very pressing, and I don't have an answer to that. All I'm concerned with is actually what should be proportionate measures. What measures are proportionate, and if we learn from shipping accidents, we know that if you choose your measures in the wrong way, if you choose measures that are too much, you may end up in a situation like Torrey Canyon. There were some ideas about like setting the gas on fire just to make sure that climate is protected. I'm not sure whether it's a joke or it's something that could be taken seriously, but this highlights this problem of balancing different interests in a way that is appropriate, that meets requirements of law of the sea convention. And also this raises, of course, all these possible issues of how, what if we damage the environment even more as we're trying to save it, who is going to pay for it? And also this allocation of costs and things like that. So we don't really have, as far as I know, binding international rules that would kind of lay out the what states should do in this with respect to pipeline accident response. But I might be wrong here. Still, we have all these problems with another issue that arises, and which states have actually considered, and which I think is very interesting now in Nord Stream. What if we cannot repair this pipeline, right? And there are some voices saying that it cannot be feasibly fixed. Should it stay on the seabed? Will we do more damage to the environment if we try to to bring it up? Will it be too costly? What can be done? And environmental impact assessment for functioning Nord Stream pipelines says 50 years of use, then it has to be somehow decommissioned. But now, obviously, states have to take a decision to decide on what should be done already now or quite soon. And then I don't know which is it. Coastal states would seem to be natural starting point, the state that has to decide about it. But then, as Dana pointed out, and it's basically coastal states have very limited jurisdiction over these foreign pipelines. It does include environmental protection, but who has to decide about it really? And it's also several coastal states involved. So this is, you don't really find good answers to these questions in international law in respect to, specifically pipeline decommissioning. And this is more or less like legiferenda thing that we should actually be debating. I think it will, clarifying these obligations would also be useful for, other projects involving seabed. Now, I think that I don't have to actually to go through all possible environmental issues that arise. I know that liability of the operators is also one of the topics that may be raised here, and who is compensating for damage that is caused. And we can also, of course, look at the criminal liability and perhaps conceptualizing this kind of acts as ecocide. I am not sure whether this concept will, at the international level, will be helpful now, because it's still in the development. But states may have nation laws, and then you have to know who's the offender here, of course, but something that we don't know yet. So this is still quite a good case, I think, for saying that this is ecocide. Now, I've read that Russia has initiated criminal proceedings for terrorism, but not ecocide. So who knows? Now, let me just finalize, or let's just wrap up by starting to bring up this question about liability and compensation. And of course, well, state liability may or may not be relevant here, but what about operator liability? Would operator be liable to compensate some damage that may have arisen, and what damage will include? I think this is a very interesting and yet unresolved question. You know that in shipping, with regard to pollution from oil, pollution from ships, we have ship owner, strict liability of the ship owner, but then so it's in a way operator bears liability. But then a case such as sabotage, would actually result in the ship owner being exonerated from this liability, right? So that's raising perhaps the duty of funds to cover up, but still, if the ship owner manages to prove that it was a willful act, damage done by third parties, then the ship owner or operator is not liable. And the burden of proof is on the registered owner in this, shipping liability regime. So what there have been some attempts to, address the civil liability issues more generally at the international level, but they're not yet fully successful. So it's perhaps also this accident gives us a chance to revisit these efforts that were already done with regard to transboundary pollution resulting from different activities. And I think that it's more than enough of food for thought and discussion now. So I will just stop here and stop sharing. Thank you for your attention.
Thank you very much, Professor, and really a tour de force. By way of general comment, I think there are more questions than answers. 4 very different presentations, and something that strikes me is that international law is very unsatisfactory, and perhaps I could start the questions by asking, is it useful to conceptualize this through international norms like armed attack or breach of peace? Or is it better to treat this through coastal state criminal law, or indeed civil law. Huh? So I just put that as a general question to the panel. Perhaps Professor Azaria, since you opened the floor this afternoon with your presentation, that this would be a very good question for you to start the discussion on. Thank you very much.
Yes, thank you for that. It's a very interesting question. I think, I mean, perhaps it's not such a bad thing that this particular incident would not give rise to a right to self-defense, because the jus ad bellum perhaps should be restricted as much as possible. It depends, of course, on how one views the vision that one has for international law and international relations. But I suspect that what this particular incident raises is one, what will states do from now on to address this? Will they or should they try to create some special regime to address this particular hybrid incidents that perhaps do not meet the armed attack threshold, and of course see what type of reactions they could how they could respond. Another question would be whether, because you raised the question of, if I'm not mistaken, you mentioned bridge of peace, and I wonder whether one way of looking at it is something that James mentioned earlier, the peaceful uses of the sea, and especially Article 88 that obliges, of the Law of the Sea Convention, that obliges all states for the high seas to be reserved for peaceful purposes, and Article 88 also applies in the EZ of other states. So there is a question, instead of really resolving what we mean by peaceful purposes and peaceful uses of the sea, because indeed military activities are not necessarily against peaceful purposes and peaceful uses, but we do not know at the moment what would be against the peaceful uses of the sea, and whether perhaps this type of scenario is not compatible with peaceful purposes at sea. So that would be an interesting scenario. And also, just to point out that I think in this respect, first of all, this would allow litigation under the Law of the Sea Convention, potentially, definitely from the coastal state, before courts having jurisdiction under the Law of the Sea Convention. And under Article 88 itself, frankly, beyond, and that in that case, you would have other states other than possibly the coastal states, in the case of the EZ. Thank you. I hope that answers, or at least open the discussion, because I'm sure that James will have some comments on that.
Yeah, of course, and you raised the issue of compulsory jurisdiction in Part 15 of the Convention. We'll perhaps come back to that issue later, but Professor Kraska, would you like to respond to some of those issues about how to conceptualize an incident such as this?
Thank you. Yeah, just to add to the great comments so far, very impressive speakers, and I'm glad to join. So I guess I would think that you do have a potential for violation of peaceful purposes. Obviously, even for the US, as I mentioned, that doesn't get you into the right of self-defense, but it does, I would think, get you into the terrain of an internationally wrongful act. With regard to criminal law, I'm afraid that I'm not sure that's going to be all that helpful, because if this is a state actor, which I'm assuming it's a state actor, then of course you have all of the sovereign immunity issues like Enrique Lexi. And so it's unlikely to, and in the US case of between the United States and Saudi Arabia over the murder of the journalist Khashoggi, US has recognized the Foreign Sovereign Immunities Act. So I think that will be very difficult. So in the end, if we're stuck with peaceful purposes, you might get some work out of that through state responsibility. And that's sort of as far as I can think on this. I'm fascinated by the environmental aspects of this, just the overall teeth that's been added to Article 192 and 194 in recent years, and I think that there is state responsibility there as well. So maybe these two lines of effort might be useful. Thank you.
Yeah, very much so. And perhaps I'd like, yeah, sorry, Professor Azaria, would you like to reply?
I just to add on and build on James's comments, I completely agree. I think Article 192 is of course, we have a problem of attribution. We cannot resolve that, at least as international lawyers. We don't have evidence and facts. Other people would have access to that. But assuming that attribution can be established, there will, and that state, assuming it is a state is party to the law of the Sea Convention, 192 would oblige that state normally not to conduct that type of activity. On top of that, under customary international law, you have the prohibition, the obligation to prevent transboundary harm. And in this scenario, if it is, it's very likely that it is transboundary because it has happened, even the activity has happened outside, and the effect outside a particular state's territory. And if it's not one of the coastal states, certainly transboundary in that sense. So I think there are ways in which international environmental law or the marine environment provisions of this convention would have a lot to say here, and state responsibility would arise, and you would have the option of litigation. And the only thing that I also want to add, again, 192, I think it's an erga omnes partes obligation. So you would have the states that would have standing to bring a claim against the responsible treaty party would be any party to the law of the Sea Convention. Thank you.
Yeah, Professor Kraska, please.
May I just offer wonderful comments? May I just offer a two-finger, which is in agreement. Another area that you might be able to explore in this case is the due regard in the EEZ, which, for military activities, those who've read my material know that I take sort of a very narrow view of due regard. But I have to say, my gosh, in this case, this is just wanton destruction, release of massive amounts of methane. Denmark estimates that it's 32% of the greenhouse gases that Denmark emits in a single year. And so I think you've crossed the due regard line in relation to the coastal states' rights. So that's another line of inquiry that I might suggest.
Thank you very much, James. And I think there's kind of two very interesting angles highlighted by my colleague, Dr. Jensen, with the issue of piracy and indeed the application of the SUA protocol. Perhaps some of the panelists would like to comment.
I'd be glad to venture if nobody has any thoughts. So it's definitely intriguing ideas. I think that SUA might be more fruitful. I'm still wondering, though, whether you can classify these pipelines as installations. Probably you can, but I think that it's something that has to be explored. They are installations for the purposes of the zone and Article 56, so they would have an economic purpose. I'm not sure that was the vision for installations during the law of the sea negotiations, but I appreciate anybody's, Dr. Sons or anybody else's thoughts on that.
Professor Jensen, please.
Thank you. Thank you for the discussions, and thanks, James. I think I also asked myself that question when I started going that way. And if we look at the background, I think for the 70, the UNCLOS 3 discussion, I think when they included pipelines and submarine cables in the 70s, I think many of them didn't envision how important they're going to become. And especially whether we would have actually just those kind of transiting pipelines without linked to offshore platform. So those are the things I think probably during the 70s, at least they were not considering their existing. For the SUA protocol, it was negotiated in 1988. I think by that time we would have quite a well-developed system in the North Sea. So there were probably cases that went through just transiting the maritime jurisdictions of a certain state, but they didn't separate the term back then. It was only used as the term defined in the convention as fixed platforms. I think it takes some interpretation to include that. I would agree that in the discussion of whether it's installation and structured in the UNCLOS sectors, they didn't separate those two terms, but it was only under UNCLOS provisions that they separated submarine cable pipelines outside of this infrastructure and installation. Whether this automatically apply to the SUA protocol, I think that's worth some consideration. Thanks. I think I'll, yeah.
Thank you very much, Professor Jensen. Professor Sasakawa.
Just to follow up on, I've taken a look at SUA convention and protocol, and I agree that it takes some interpretation exercise to determine whether its provision may apply to pipelines such as Nord Stream. And I think I managed to see that, yeah, it could apply. And then then the question is, of course, what's done? What happens next? How can we use this convention to go about what is going on or what went on before explosions? You know, those ships that appeared there from nowhere, and as we know now, and maybe they have started doing something illegal at sea. Would coastal state, I guess Denmark, send coast guards and you know, stop the ships? Do they have jurisdiction to do that beyond territorial sea? What does convention say about SUA convention say about it? I think my understanding of this convention is that it still requires, you know, cooperation between coastal state and the flag state of a ship suspected of. So it kind of doesn't give you more jurisdiction than Law Sea Convention does. I mean, the coastal state, but it's certainly a fruitful instrument to take a look at. But I also had, can I just, I now forgot what it was, but I think that when it comes to using the, you know, environmental law as a sort of as a solution to expand on state responsibility. Of course, Law of the Sea Convention 192, other provisions, they provide a good possibility to expand state responsibility. Contribution is still, of course, an issue. But then your question about criminal laws of coastal states, for example, you know, one of the problems that just pops to my mind when it comes to environmental crime, if we take a look at that, you know, willful conduct as environmental crime, then some states, I haven't researched all these Baltic states and then other states, the Baltic Sea, but many states have very restrictive approach to extraterritorial activities, you know, when criminalizing some conduct, and it's not far from certain that that national criminal legislation actually applies to crimes committed outside its territory, where there has to be some kind of double criminalization or whatever. So I think this might be a way to go when you, at least when you are able to identify the responsible, but you can still be precluded by the geographical limit of your national criminal law from pursuing this successfully. And of course, now we don't even know if it was indeed science fiction private actor. We don't know who it was. So
yeah, thank you very much. And it's a very, very important point that you've made. Before I go to Professor Azaria, perhaps a question which the panelists could reflect on is this something that countries should be legislating at a national level, or is this something we should be addressing at the regional level? And I would make reference to Ala's intervention on HELCOM, or indeed is this something that we need to look at a multilateral level? And of course, the ILA is, we've a co-reporter without prejudice. Of course, you're standing within that association. Perhaps you might comment on that. But next, let's go to Professor Azaria.
I almost would prefer not to answer that, because I think it would be very interesting to hear instead what the colleagues have to say, as we are in a process of consolidation in this respect, of whether perhaps either we propose some guidelines or perhaps something more concrete that could lead to something more concrete, i.e. binding law through in future negotiations in a treaty. But I just want to point out, and so I encourage colleagues to perhaps indicate their views, but I wanted to point out that building on Zen's and Ala's comments, that Article 113 of the Law of the Sea Convention indeed addresses the situation where a person under the jurisdiction of a particular state that is part of the Law of the Sea Convention willfully breaks a pipeline, but on the high seas, and that provision applies also in the EZ of another state. But what the problem is with that article is that it only obliges treaty parties to exercise prescriptive jurisdiction, in other words, to adopt laws and that prohibit this particular conduct. It doesn't specifically indicate anything about enforcing, does not require them to exercise their criminal jurisdiction and prosecute, for instance, or enforce. So that is where this particular provision becomes very also particularly insufficient here, because even on a state responsibility level, we could be arguing that a state that does not prosecute, for instance, or does not investigate, then there is state responsibility, breaches its obligation under 113, and so there is state responsibility. But we cannot even say this, because the only thing that this provision provides is simply to adopt laws. So that's one thing that I wanted to point out, that there are some aspects of the Law of this Convention that deal with this, but up to a particular point. And that's perhaps why a particular treaty might be an option for the future, but we need to constantly be very aware of fragmentation. Constantly creating treaties is not necessarily an answer. And so this is a bit of a balancing act.
Thank you very much for that intervention. Professor Jensen, please.
Thank you. That's precisely what I wanted to comment on. We have exact provision in UNCLOS that would apply to this situation. But the difficulty is, first, I think if we look at the national legislation, not many states has even adopted national laws to regulate their own ships, their own nationals. And the second, in a particular case, is that we don't really know who is responsible for this act. We assume it is done by a private ship. It has to be a private ship to begin with, and how to associate it to a state act will probably be the secondary consideration. And I think if we look in the future how to protect this critical infrastructure under the seabed, including cables and pipelines, I think one thing to consider is whether we can clarify the ownership of those critical infrastructure as a starting point, like giving them options to register with the state, or kind of having international organization to come up with protections, or something playing a similar role to the IMO is playing for the shippings. That could be another thing to think about on the international level. For individual state, I think the primary thing for them is to really think about the importance of those infrastructure and to start legislation to implement their obligations under UNCLOS to begin with. Thank you.
Yeah, and of course, Pacta Sunt Servanda, of course, there is, rights and duties go hand in hand, and we would have to emphasize that the rule of law is paramount, as well as peaceful uses of the ocean. I think one of the key issues flagged in a number of the presentations this afternoon was the issue of liability and perhaps the scope for the development of particular mechanisms or funds to address these types of incidents. Would the panelists like to comment on that? Yeah, Professor Sasakawa, please.
Just a very brief comment, because I had slides on that before, but I think that we should, I think we should work on compensation, liability compensation mechanisms, and I think it's important perhaps to look beyond just this actually quite crazy situation with the willful destruction of pipelines. We should rather consider, this environmental and other damage that can arise just because of an accident or a leak that is not attributed to someone's criminal activity or sabotage. I think it's important to pick up the work, which probably it's not exactly my field, pipelines, but still it's important to build on the work that is already done to develop rules at the international level, harmonizing compensation possibilities for the victims arising from damage to critical infrastructure and gas and oil pipelines. That would be the most important. And indeed, this is also the obligation that states have under international or the sea. The states have to endeavor to harmonize and develop the rules at the international level, addressing the problems of compensation. So states should do better on that.
Yeah, we have quite a burgeoning volume of international jurisprudence, both from the International Court of Justice and indeed the International Tribunal for the Law of the Sea on the obligations of due diligence. And these are very important obligations, but of course, ultimately, it's how to redress the damage. So liability, I think, really is a core issue to address going forward. Just perhaps an interesting aspect of this, which some of the panelists might like to comment on, is can we draw distinctions between infrastructures pertaining to cables and pipelines, given that it's perhaps the damage could have devastating economic impacts in itself. So I'll put that to the floor. Professor Azaria and Professor Kraska.
Of course, under the law of the sea, there are some differences. They have been approached initially together, but there are some distinctions, including in terms of the consent to lay a pipeline a state's continental shelf, and other provisions. But I think that what your question is really about is that they raise different vulnerabilities, and because they have different functions. First of all, pipelines are primarily relevant for energy security. Cables are relevant both for energy security, but also for telecommunications. So they will raise different effects in different fields, although, of course, both these issues, telecommunications and energy security, are critical for states. And so, of course, they will have an impact on how we address, for instance, environmental effects, environmental damage, right? So the pipelines are more likely to involve much more environmental damage in case of an explosion than a cable. So this is where I think they have to be seen as different, because they will involve different scenarios of violations, and different scenarios of also particular interest in making claims about those violations.
Thank you very much for that. Of course, there's a very important distinction between the two. Professor Kraska, please.
Just to add the great comments, just to add a few more of the distinctions, which is, of course, that when pipelines are bilateral, that means that the effects are concentrated on, most likely one party or two parties, whereas with submarine cables, the effects are disaggregated or diffuse, and in fact, may even be unknowable because of the nature of the global internet system, where there's automatic rerouting of traffic in, at the speed of light, so to say. And so it's often unknowable. And also the owners that might have a indefeasible interest in the submarine cable are sometimes unknowable because they're subleased, and nobody knows exactly all of the stakeholders on a submarine cable. That's very different from a pipeline. If I could circle back to just to add one idea to what Professor Poznadkova mentioned, and this is that it might be worthwhile to look at an analog to the 1969 Civil Liability Convention that we have for oil pollution. And if you had something like this for pipelines, it might be able to spread the costs. Of course, it doesn't prevent, it's reactive. And of course, it can be gamed by adversaries, and it probably would be, but nonetheless, it would still spread the costs of addressing the fallout and the cleanup and the effects. Thank you.
Professor Jensen.
Thank you for the discussion. I want to add to a practical kind of difference in between those two industries. I think submarine cables have largely operated off the mark of international regulation for over a century, and I think, but they are coordinated among themselves. They have a ICPC. It's a private industry correlation. What happens with dealing with maintenance and repair is that the cable owners came together and chartered a specialized repair ship and docked at critical ports around the world. So what guarantees them is that when there is a cable failure or a break, that they can reach a certain faking point within 36 hours. And adding on to the economic cost for this incident, each repair is a multi-million-dollar question mark behind it. For cables, I think most of them operated under marks. There are many breaks around the world at any given time. I think the industry taking the cost, they build it into their operations. So make sure that the cable do not get interrupted. If there's a case happening between cables, there's always extra capacity when they build the cable. For example, if a cable has only commercialized 80% of its capacity, so this 20% is reserved for emergency backup. If a cable running through the same road went into trouble, they can use those backup on the other cable. So we don't normally get notified if there's any incident among a cable. For pipelines, what's different is this is a unique case because it's a trunk-passing pipeline, does not link to any operating platforms. For a lot of the existing platforms that they are part of on the EEZ or the continental shelf, which is part of a national jurisdiction, we don't normally hear them because they are off the radar for international law. And I think that's part of the reason why I think they are not really aware of the critical importance for them, for their connections around the world. I think, well, I'm reaching time, so I will stop there.
Yeah, thank you very much, Professor Jensen, and that distinction is very, very important. I would say to our global audience out there, you've posted some great questions. We haven't got around to all of them, but what we will do is if you share your contact address, we will get the panelists to come back to you on your specific questions. So those that haven't had questions answered this afternoon, we will come back to you. Last thing I have to do, apart from thank these wonderful panelists, is turn the microphone over to my colleague, Dr. Reen Derrick, and for some closing comments now to finish out our interesting webinar this afternoon. Dr. Derrick, you have the floor.
Thank you very much. Wow, what a discussion. It's been really fascinating. And I think we've really made great ground in clarifying some of the legal kind of issues that might be at stake here. Kind of wrapping up, I think there's been a sense that we're either faced with a situation where it's not obviously apparent that any or which international legal regime may be implicated, or so many are potentially implicated that we have some difficulties in choosing and in evaluating the strengths and weaknesses of each, and particularly importantly, the consequences of each, with a view to kind of thinking about what we want to achieve. And especially, I suppose, thinking about achieving cooperation. And it's striking that perhaps while some of the commentary around this incident can tend to refer to domestic criminal jurisdiction, I think our conversation today may well indicate that if we are to try to conceptualize this through some of the international legal regimes we do have, with the exception perhaps, of course, of Jus ad Bello, we can perhaps move towards a greater sense of cooperation and also more effectively think about the challenges we might face in the future from damage caused to or threats towards subsea infrastructure such as this. And there's really been an awful lot of hugely interesting food for thought from all of the speakers about kind of how we might think about that going ahead. So I will conclude our webinar there and say thank you once again to such a wonderful panel of speakers and also to our very large global audience. It's been a great pleasure to welcome you, and thank you very much.
Thank you. Bye.